Hello everyone, welcome to Contractual's YouTube channel. Today's topic is establishing a joint venture. A joint venture or JV is a business agreement in which two or more real or legal persons that are independent from each other, both legally and economically, combining their resources in order to undertake a common commercial task. Joint ventures can be established in the form of an ordinary partnership or a commercial entity, such as a joint stock company or a limited liability company. There must be at least two partners in order to establish a joint venture. Real and legal persons, either public or private, can become partners. However, it is not permitted for a joint venture to become a partner in another joint venture. Ordinary partnerships that were established by two corporations can be registered at the trade registry offices, if its founders request to do so. It should be noted that the joint ventures still do not have legal personality under Turkish law. It is now possible to register the joint ventures at the trade registry, which will provide them a legal framework as well as a corporate outlook. For a corporate joint venture, the respective minimum capital requirements will apply. For establishing a contractual joint venture, there is no minimum capital requirement. The expenses of the joint venture are covered by the partners according to their shares in the joint venture. Contribution in kind is permissible for both types of joint venture. For the contractual joint ventures, for example the ordinary partnerships, the Code of Obligations expressly states that each shareholder must subscribe to their share capital either with money, receivables, or other assets or services. While establishing the joint venture, certain approvals or licenses may be needed depending on the project to be undertaken by the joint venture, such as a construction permit from the relevant ministry, license from the Energy Market Regulatory Authority, or the approval of the Competition Board. In principle, unless otherwise stipulated in the partnership agreement, the decisions must be taken anonymously, and all the partners are entitled and obliged to participate in the management of the partnership. Unless otherwise agreed in the partnership agreement, the partners are jointly and severally liable for the losses of the partnership, as well as against the third parties for the debts and obligations of the ordinary partnership, no matter how much capital each of them injected into the partnership. Only those partners who contribute their efforts or labor instead of cash can be kept immune from the losses of an ordinary partnership. Partners can choose their joint venture to be subject to corporate tax. Otherwise, each partner will be directly subject to the corporate or income tax for the income generated by the joint venture. In the latter case, the joint venture is only liable for the payment of VAT and withholding tax but has to pay neither corporate nor income tax. In principle, a corporate joint venture is established for an indefinite period of time. On the other hand, contractual joint ventures are normally established in order to undertake specific projects and are usually dissolved once the project is finished. A contractual joint venture formed as an ordinary partnership will be dissolved in one of the listed situations stated in Turkish Code of Obligations. The partners altogether have to follow the liquidation procedures of an ordinary partnership. However, this duty can be given to one or more partners by agreement.